Welcome to another edition of The Oath and the Office. I'm John Fugelsang. It's so good to be with you, and I'm so pleased, as always, to be joined by Professor Corey Brettschneider, the man who is the author of the book, The Oath and the Office, A Guide to the Constitution for Future Presidents. He's also the author of The Presidents and the People, Five Leaders Who Threatened Democracy and the Citizens Who Fought to Defend It. He spends his time enriching the lives of students in the poli-sci department at Brown, but here it's my constitutional law class every week. Professor Brettschneider, thank you so much for letting me do this as part of my parole. Hello.
Thank you, John. And, as listeners know, I can't say it enough. What a great partnership we've had. And I continue to get questions. We will have an episode next week where we do a bunch of questions, and we'll do a segment on that. And the reviews keep coming in. And, we're in a time of crisis, but people are also looking for hope. And that's what we're providing. And we'll continue to tell the truth, but also leave people feeling like citizens can recover this democratic constitution.
Well, let's talk about it because after decades of threats, the former host of Celebrity Apprentice has become the first American president to bomb Iran. We just spent billions of taxpayer dollars to bomb a sovereign nation with no form of congressional approval. Without solid evidence, they were building a nuclear bomb, and we tore up the agreement that kept them from building a nuclear bomb. So we're in the middle of a hot mess, dumpster fire, foobar, mishigash, raccoon with a blowtorch, gaslighting goat rodeo, cats on meth, parade of flaming shopping carts, MAGAgeddon. Corey, the economy's rattled, troops are on alert, Republicans are fighting each other, and oil prices are twitchier than Don Jr. after a mid-dinner trip to the men's room. And amidst all the fallout, all the lies about ceasefire, and lies about regime change and intelligence, and lies about Obama's nuke deal tearing it up made us safer, and lies about the complete and total obliteration of Iran's nuclear supply, the question is, was this legal? I mean, the ability to declare war falls solely on Congress, although Trump and most other presidents have argued they can wage smaller campaigns on their own. But the Constitution does says Congress is supposed to authorize a president getting involved militarily at any level. So, Professor, what to make of all this? I mean, was Trump's attack on Iran legal under U.S. law, or was this an unconstitutional act of war?
I'm going to give an answer to that eventually, but I'm also thankful that we've got this in-depth podcast where instead of having to just give sound bites, we can really get into it and talk about the complexity. And although on some issues I am, as you know and listeners know, willing to say, look, there is no question the president has acted in an illegal way here, full stop. No, you can't send people to a gulag in El Salvador. No, you can't just shut down dissent. The Constitution's meaning is clear, I think, in a lot of areas, and a lot of the crisis that we're looking at has that quality. This is a little different because there is a complexity to it. So instead of just saying, here's the answer, I'm going to just lay out why this is so complicated.
Please.
Let's start with the Constitution itself. And John, please, we have talked about this, but I'm trying to get clear, but it's such a complicated area, as I'm sure I will be unclear. Please ask me to be more clear. So the
Sure. And by
problem.
the way, you could ask me to interrupt with more sound bites that provide nothing, but no form of nuance whatsoever. I have many more offensive jokes, but please go ahead.
Well, I
Just,
was thankful for your rant because I was also like, oh man, how am I going to present this? And gave me a little time too as I was listening. So the complication comes from the fact that the Constitution, look, the British kings had a unique prerogative war power. They decided both whether to start a war and they decided too how to carry it out. And what the framers did is they took that prerogative singular power and they divided it into two. And how did they do it? They gave the power of commander-in-chief to the President of the United States. That's in Article 2, which all the way also has our oath clause that our podcast is based on. And Article 1, the Congress was given the power to declare war, as you referenced in your opening. I won't call it a rant, I'll call it a monologue. To declare war, meaning to initiate war. So now the dilemma always is, well, what power is at play here? And to add to the kind of history and complexity here, Congress at one point was very worried about what was widely known as the imperial presidency, that basically Congress's power to declare war, as you said, was just completely ripped apart. So what they did actually at the end of the Nixon administration to rein in that war power is they passed something called the War Powers Act. And what the War Powers Act did is it laid out a series of rules about how to balance these two powers, on the one hand, power of the president as commander-in-chief and the power of the Congress to declare war. And what they said was that yes, a president can, short of war itself, and we can get into that, initiate an action, either defensively or even aggressively, as long as they reported on it to Congress, and most importantly, within 30 days, the Congress either authorized it, or they could also extend it for another 30 days, so within 60 days at least, either authorized it, or if they didn't authorize it, the default was the action abroad had to stop.
Hmm.
Now, and one more caveat, Congress also, under the War Powers Act, clearly could stop any action at any period. So now we'll get into it. Is this a war? Maybe. If it is a war, you can't just start a war. But is it a limited action? Maybe the president under the War Powers Act can do this. The problem, I think, regardless of where you stand, I know we'll get more into it, is that Congress hasn't acted. If Congress wanted to stop this, it could, in the moment. We now have a ceasefire, but they could pass a resolution that says no more. We haven't declared
Right.
war, full stop. So part of the problem is here, they've abdicated their responsibilities in the moment to opine on this, which they should be doing. And the other thing is the War Powers Act itself, although it was meant to rein in executive power, you could see how it opened the possibility of a circumstance like this. So it's not necessarily illegal. That's the bottom line, unlike a lot of the
Okay.
actions that we've talked about.
Okay. Now's where I ask you a string of very dumb questions.
No, my mom told me there are no dumb questions. I think if I had any academic success, it was because she listens, by the way. So thank you, Mom, for saying
Well, okay.
that.
Now, again, we have not legally declared war in this nation since December of 1941. We've been at war almost constantly since then, but we haven't legally done it since then. I know Article 1, Section 8 of the Constitution gives Congress the power to declare war. Clearly, that is not what happened here. But can you walk us through what kind of legal fig leaf, if any, the administration is using that says it gave him the authority to bomb Iran when he didn't tell Democratic members of Congress in advance, nor any of our allies?
Well, they've been saying all sorts of things that don't necessarily help them. So instead of saying what they've been saying, and these are not the brightest bulbs working for Trump or even defending him, but the best defense for the idea that what he's done, and many other presidents, including Obama and Clinton, made similar arguments. So this isn't, I think, just an instance of a Republican president going astray. It's consistent with the arguments of other presidents. The argument is, look, yes, there are these two powers: Congress declare war, and the president has the power as commander in chief. But there's this specific law, the War Powers Resolution, that worked this out in a way that might make what he did legal. How did it do that? It gave the president 60 days to begin action. As long as it was eventually approved, it could continue, and otherwise it can't. So we're well within that 60 days of the attack. It's only a few days. And so that's the argument, that under the War
Okay.
Powers Act, that's where he's getting his authority from.
Now, let me ask about the War Powers Resolution 1973. As you said, it was originally supposed to rein in presidents after Vietnam and
Yeah.
Cambodia. Obviously, pretty much every president since has found a way to ignore it. Does this law actually have teeth anymore, Professor, or is it just a sternly worded suggestion?
I think, there are flaws with it, and I'm going to criticize it, and it's criticized in both directions. The president, actually the president's allies, especially the Speaker of the House, has criticized it, and he is himself a constitutional lawyer and fancies himself a constitutional scholar, and he criticizes it because he thinks it reins in executive power too much. So what he's doing to try to prep the fact that even if Congress doesn't approve Trump's actions in 60 days, it can continue, is he's been saying the War Powers Act is unconstitutional. But the fact that he needs to do that shows its power, that there really is this expectation that the President of the United States will go to Congress at least within the 30 or 60 days.
Right.
And so I think that is teeth. And, there are examples of it actually mattering too. Jules LaBelle, a friend of mine who teaches at University of Pittsburgh, sued the first George Bush Sr., for his actions in the Iraq war, saying that he hadn't gotten an approval from Congress. And while the president of the United States at the time, very different president, of course, than Trump, initially tried to argue in court that he didn't need that approval, under pressure from the court said, my understanding is not, they didn't actually say it was illegal. It said that there wasn't really standing, or the question wasn't ripe yet to take the case, but they said in some of their opinion, yes, you need to go to Congress, and he did. So there was a resolution in that war. So that shows that, yes, it does have power. Now, in my view, it should be recrafted. And I argued in my book, The Oath in the Office, for a rewriting of it. I do think we should have a statute, but one that says not 30 or 60 days, but any action needs to be approved by Congress. That would be a way of reining in a president even more. So, to my mind, that more closely fits the meaning of the Constitution. So there are arguments on both sides that it restrains executive power too much. That's what you're hearing from Trump and his allies. And then my view, which is no, it gives too much power to the president. But as bad as it is, as flawed as it is, to answer your question again, it has teeth, it does matter, and it's something that we should be using as a resource in making sure that this president doesn't engage in a protracted war without congressional authorization. And that, more importantly, that we get the Congress to do its job, which it hasn't been doing, which is to opine. Are you okay with this
Well,
action
that's
or
it.
not?
Yeah. Is the problem that it gives too much power to the president, or is it the problem that it gives away Congress's war powers?
I think that it allows Congress with this 30 or 60-day period. Again, it doesn't, after 60 days, if Congress has done nothing, the president is supposed to withdraw from any future action. So that's a real limit. But, to my mind, the way it's supposed to work is they're not supposed to just wait as long as they can. They're supposed to use the moment to opine. Is this, do we want this or not? And are the American people behind this or not? And in refusing to debate, they're showing a flaw of the resolution, which is that 30 to 60 days, seemed to the drafters of the War Powers Act, or sometimes called the War Powers Resolution, it seemed to them to give a lot of power to Congress to reclaim it from an imperial president. But it's turns out that that's a long period of time when it comes to war. It could be too late, by the way, if these actions get so intensified 60 days in, now we're in a war, Congress is not going to pull back. So, it has restrained beyond what people like Trump want, but it does have teeth, but in my mind, it is deeply flawed.
Okay, I have more legal questions about this wily coyote rake stepping in a minefield, nuclear clown car, Kool-Aid faceplant, turducken of train wrecks.
Can I just say one thing about the nuclear thing? Because
please.
I do think that's a crucial thing. And, another reform that's so crucial is when it comes to nuclear war. There's a proposal called the First Strike Bill that would say that in no circumstance can a president initiate a first strike of a nuclear weapon, because that is a war, and that there's no war powers nuance to it. That's something that's urgently needed and that we don't have at this moment. And the fact that we have this president in control of nuclear weapons is among the most frightening things about the current moment.
Well, let me just ask for all the neocons listening. Trump never got a new authorization for use of military force, an OMF, and his team is trying to stretch the 2001 OMF like it's silly putty across decades and continents. Is there any legal logic to that, Professor? Or is this just another case of post 9/11 legal zombieism?
Yeah, there I'm going to be, take a strong stand. Look, this is a new action, a new conflict with Iran over, its conflict. It's a sort of embedded in connected to the conflict with Israel, connected to the question of them acquiring nuclear capacity as Trump's team sees it. So I think it's just obvious that you would need a new resolution beyond that 60 days if this is going to continue. There is also, I should say one more thing. There is an argument which I haven't quite made, because I'm not sure about it, which is that this action is so severe, the attack was so severe, that it is a declaration of war. But the fact that there's a ceasefire now, that helps Trump's argument that no, it could be a one-off.
Okay, so then let me get to the really scary question. Legal scholar Asha Rapanga talked about this, warning that if we are now officially in some way at war, even though we haven't declared it since 1941, if we are at war, Trump's powers would expand dramatically, from being able to invoke the Alien Enemies Act to federalizing the National Guard. Not that he's having much trouble with that, but this is what worries me. What kinds of unchecked powers could this open up for him? How worried should we be about that?
I'd have to hear what she said more and what she's thinking about, but it is a common view, I should say to begin, that in war, the commander-in-chief power comes with all sorts of domestic authorities. And I just think it's wrong that when you look at the history of the founding, when you look at the case law, that although there has been a current that stresses the notion of emergency powers inherent in the commander-in-chief power, I just don't believe it. I think there's a long history, including, I'll just give the most important, Justice Jackson, who had been a Nuremberg prosecutor, was really worried about the idea of inherent emergency powers, including a war power. And he argued that essentially that no, that Congress can rein in the president in peacetime and wartime. That case, Youngstown is the name of it, and his famous concurrence there is so important because it essentially rejects the idea of inherent emergency power. So no, I don't think anything that you and I have talked about when it comes to the rights of non-citizens to free speech. The Khalil case, Khalil, by the way, just to update listeners, is now out as a result of, in part, the ACLU's efforts. When it comes to the deportations to this gulag that we're going to talk about later in El Salvador or possibly Sudan, no, the president's powers aren't increased. So, I just think it's a misinterpretation of the Constitution, both by the president's critics and his defenders, to think that he gains any additional domestic powers. Now, it's not to say that there haven't been terrible decisions by the Supreme Court that have said just that. So, in the famous Korematsu decision about the roundup of Japanese citizens into internment camps, the worst decision, not the worst, Dred Scott is the worst, but one of the worst in American history, top 10. The court reversed that and acknowledged the terrible mistake that it made. So there are these moments, yes, where courts and presidents have claimed to have extraordinary powers in war, but I just think it's core to the meaning of the Constitution that they absolutely do not.
Okay, I'm almost done on this Iran bombing, Corey. I really am. But just a
So to
few more
speak.
questions for those who remember that we did have a working nuclear deal with Iran, and our own Pentagon was insisting they were abiding by it. I mean, Bush and Cheney at least asked for a permission slip before their illegal war. I don't know what it says that Trump didn't even bother, but it seems like the greatest danger here, and some of our conservative brothers and sisters realize this, that if this kind of strike becomes normalized, couldn't any future president unilaterally launch strikes anywhere, anytime, no vote, no debate, just a hashtag and a press release, and boom?
Yeah, and that's why we need to rein in the War Powers Act, not give this 30 or 60-day period. It's part of what's allowed for it. This president and many presidents try to go in the opposite direction. They don't want even that 30 or 60-day constraint. But let's not just this is a really important, moment in which I think we have to be really careful to not think this is a partisan issue. Presidents of both parties have really aggrandized the war power. And I'll mention too, Obama, a constitutional law
Yeah.
scholar. Actually, I had the privilege of teaching the same classroom at University of Chicago Law School, teaching First Amendment in the same classroom that he taught constitutional law. But yet, as president, he really just did not do enough to respect the limits on presidential power. So, for instance, he claimed that even when it came to a citizen on a drone kill list, that there was no due process rights and that he
Yeah.
invoked the commander-in-chief power. And, we could go to Clinton and Bush, too, to think about their willingness to really push the limits at minimum of the War Powers Act and to aggrandize presidential power, complying maybe with the letter of the law, but not its spirit. So this is a long-standing problem of both parties. And
Yeah.
absolutely, we need to rein it in. We need to have a period after this administration in which we recover by thinking about rewriting the laws to reinforce the Constitution. And top of my list is the war powers, reining it in. I hope we'll get to that point. I know there's skepticism that we
Yeah,
will. I'm
that's
hopeful that we will, but that's
exactly
on
what
the
I
top of my list.
what I said after Bush, and what I said after Obama, and what I said after Trump. Let me ask you one last question on this, Corey, and then I'll get off of this, and we'll talk about the Supreme Court to terrify everybody. If Donald Trump's bombing wasn't legal under U.S. law or international law, and he's now claiming ceasefire powers that no one else seems to acknowledge. I mean, both sides were still bombing each other during his cease. It was like he was directing Ceasefire the musical, and the actors were all beating each other up in the wings. What should the international community do next?
Well, I should say too that as much as I've tried to talk about the law and the War Powers Act, I also want to get real here for a second. Courts, aside from the example of Jules LaBelle, my friend, who successfully seemed to intervene in pressuring Bush to seek a resolution, and we should have him on the show at some point. Courts really don't get involved. So courts don't enforce international law. They don't enforce domestic law when it comes, and meaning the limits of the war powers, even the war powers resolution. So we're in a moment where this is really about politics, and there's international pressure, that might play a role. There's, in a weird way, a coalition going on of Democratic Congress people worried about the war powers and abuse of the war powers by this president, and also the president's base, MAGA, who say, well, you campaigned on being a peace president, that you are, he said at one point, I am peace. Well, what happened to that? So that politics plays in. The Constitution comes back in that there is one thing that can be done. It's not courts. It's not some kind of international court of justice. I don't think is going to make a difference here, or the International Criminal Court. I don't see it acting. The one real possibility, and this is where all of us come in, if you feel strongly about this issue, is Congress does have the ability to stop this tomorrow. And how do they do that? All they need is a majority of both houses. It's called a concurrent resolution. The War Powers Act specifies it. And if they were willing to debate and act about this, they could stop U.S. intervention in the Middle East. And you do, most of the issues that we talk about, it's just not realistic to think the votes are there now. We're often talking about what the next Congress would do. But here, maybe there would be. Thomas Massey, for instance, who's come out as an anti-Trump figure. Marjorie Taylor Greene, I found myself agreeing with at one point. That felt very awkward.
Yeah.
So maybe we do have a coalition. Congress needs to do its job. And this is one of those areas where you can, of course, write to your congressperson and urge them to, again, do their job. It's a duty under the Constitution.
I could spend about 2 hours talking about how Donald Trump was never actually an anti-war candidate or president, but I'll leave this segment with you finding common ground with Marjorie Taylor Greene, because when we come back, I want to talk to you about the Supreme Court, because now we're pretty much allowed to deport asylum seekers to any country where they might get killed instantly because 6 of the judges say so. I don't understand this particular cruelty, Corey. Well, let's take a quick break. When we come back, I want to pepper you with some questions about this, because people really need to know what they're doing and what the DOJ is trying to do to get around the Supreme Court. We'll be right back on The Oath in the Office. Welcome back to The Oath in the Office with Professor Corey Brettschneider. I am John Fugelsang. Corey, I want to talk about the Supreme Court and the human rights and legal angle of deporting people. They have just allowed Trump to deport legal asylum seekers, because if you're standing on our ground, you're allowed to claim asylum. And now we're allowed to ship you off to countries like South Sudan, where civil war and ethnic violence are life-threatening and ongoing. I don't really understand any of this, so I'm going to ask a lot of dumb questions. But how did this ruling come down, Professor, and what was the rationale?
Oh, I just have to invoke my mom. If she was here, she would say, John, there are no dumb questions, and that's asking questions is how you get to the truth. So that's what we're all
Okay,
about here.
if you say so.
If I say so, if my mom says so. I wanted to actually make just a quick point as I transition to this question about the last conversation, which is the reason we went so in depth, and it was so important to talk about it that way, is the framers saw something that remains true, which is if you go to war, it sucks up all of the energy of domestic policy. It risks abandoning civil liberties at home, despite what I said about there being no emergency powers. And so that's why it's so important. And now to return to this more domestic issue, although it has international dimension to it, the Supreme Court has just done something horrific here. I don't want to be nuanced about it. It was terrible. They used something, first of all, called the shadow docket, which is usually they give opinions. They write out their reasons. We know why they did something. But when they use the shadow docket, it's just essentially an order, what they call an emergency order. And more they're using it to hide their abuses of the Constitution. And that's what's going on here. There was an amazing dissent that really put the stakes in stark terms. So what's going on here is that a district court judge stopped the taking of individuals with no connection to Sudan and other nations and sending them there. And there's all sorts of legal restrictions on sending people to countries in which they might be tortured or countries in which they have no connection. And these deportations to third countries really risk torture in the worst sense, and certainly, and there is no connection of the people often being sent. And then let me just go beyond the dissent. Mike Zamore said to us when he first joined us, and I think he said it again last week, this is the policy director, of course, of the ACLU, who are doing so much of these suits, who are bringing these cases, finding them and stopping them. He said, when you don't have due process, as it looks like you're not going to have here, you don't even know who's being deported, that there could be citizens or non-citizens. Certainly once they're in Sudan, there's no control over what happened. So the idea that we'd be able to stop torture after it happened is absurd. So this fiery dissent really says that in allowing these deportations to third countries, the court is doing no less than abandoning the rule of law. That's not an abstract thing. It really means that we're allowing people under the control of U.S. jurisdiction to
Okay.
risk torture.
So here's what I'm wondering then. What does international law say about deporting nonviolent people to places where they could face torture or war or death? Are we violating treaties here?
Yes, we're violating a treaty, Convention on Torture, which the U.S. is a signatory to. And there also are domestic equivalents that ban the deportation or the kidnapping, I should say, of people and sending them to these third countries where there could be torture. Of course, America, sells itself to the world as a beacon of democracy. And if you're a beacon of democracy, what does that mean but to prevent torture? And let me just say, too, aside from these statutory prohibitions, we have an Eighth Amendment that says you can't have cruel and unusual punishment. That was a resistance to the unusual punishments of British kings who did things like chop ears and brand people. It was meant to be a democratic protection of the idea that no human being should be subject to the deliberate infliction of pain. And yet, what are we doing? We're not doing it here necessarily, but we're contracting out to third-party countries to
Yeah.
allow it to happen. And that is a violation of international and domestic law. Unlike in that previous conversation where I was being nuanced, I don't see any nuance here. I think the dissent is right. We're in the middle of a coup, and part of what that coup is about is usurping the judicial power to protect against the most basic of human rights, including the right not to be tortured.
Well, and here's the thing. I mean, if a country is dangerous enough to have to flee from, it ought to be too dangerous to deport people back to, especially if they don't speak the language or come from that country. But we seem to be saying you're on your own. Corey, what role did the court's conservative supermajority play in greenlighting this? Are we just watching the deliberate systemic erosion of refugee protections by judicial design?
Well, I think there's an ongoing dilemma. What they did specifically was give an order to this lower court judge to undo his blockage of these deportations to Sudan specifically. How this is going to play out in the wider issue? Of course, it's not just Sudan that they're using for these deportations. It's also El Salvador in the case of the Venezuelan deportations. So they haven't given a final argument about that, and that is, I think, not something that's going to be done on the shadow docket. They're going to have a case. They're going to have to ask this question. I'll just lay it out. Do American, not just citizens, but non-citizens have a right to due process? And due process under the 5th and 14th Amendment is given to persons, not to
Yes.
citizens, to not be deported to a torture prison in a foreign country. And to my mind, we'll see what the court's going to do, but they're going to at least have to go on the record. I mentioned the Korematsu case, a horrific case to remind listeners where during World War II, the Supreme Court upheld FDR's executive order interning Japanese Americans. Now, they gave a rationale based in security that we now know they didn't believe, and that actually is not true. There was no threat from Japanese Americans at the time, but at least we have a record of it, and we could go back and condemn it, and the court has
Right.
reversed that case and apologized for it. And that's what we need now, even if this court is going to do the horrific thing and okay these deportations to these third country prisons. Let's have a record of it so that history can condemn it.
Well, okay, so with that in mind, let me shift gears just a bit and talk about oppressing refugees from the government side, not just the judicial side, because we spent some time last year, Professor, talking about Emile Bove the third. Am I saying his name right? I should know this. Bove? I don't know. But now he's a senior Justice Department official, and he told his subordinates that he was willing to ignore court orders to fulfill Trump's lethally aggressive deportation campaign. And this all comes from the whistleblower who was fired because he told the truth to the court in the Mahmoud Khalil case. Bove is talking about disregarding court orders, and other top law enforcement officials seem to be very willing to stonewall or lie to judges to get their way. I mean, when a whistleblower tells Congress that a top DOJ official is telling underlings to ignore court orders to stop deporting people, where do we begin on what the legal implications are of this? I know that they're going to just say that Mr. Rubenini, who's the whistleblower, was fired for telling the truth, so he's got bad blood. But I mean, this goes way beyond contempt of court here.
Yeah, I mean, and one of the nice things of what we're doing here in the midst of something that's not nice, which is the history that's unfolding before our eyes, is creating a record of all of these things as they occur. And one of the amazing to me episodes was with Mike Zamore the first time that he came. And he recounted in depth how the ACLU had gone to court to stop the Venezuelan third-party deportations and had won. The judge said, don't do it. And in fact, there were planes in the air, and he said in court, turn those planes back. Now, the administration came up with this ridiculous argument that, well, he said it, orally rather than wrote it, and that somehow they weren't
Hmm.
bound by it. But we know they disregarded that order, and we know that there are others that they have disregarded. Now, what we have, and this is history unfolding, is not just the fact that there was not compliance, but that the non-compliance was intentional and ordered by somebody very high up in the DOJ. That lawyer, for instance, in the deportation case to Venezuela, that judge, I should say, whose
Right.
order was disobeyed, is seeking contempt charges. Now, there's a complicated story that we could get into about how that might or might not happen. But now we know. He wanted to know, who did this? Who's responsible? Is it just some underling? No, it's not an underling. It's this Beauvais character is very high up in DOJ. And in fact, it doesn't necessarily stop with him. It might be
Yeah.
Pam Bondi. And as much as the president of the United States, if he ordered it, likely does have criminal immunity under that terrible immunity case, Pam Bondi does not. And neither does Mr. Beauvais. And if
Right.
that sounds far-fetched that we'd see the prosecution of an attorney general, you need to only look at the Nixon case, where there was a prosecution of an early attorney general for Richard Nixon.
Yeah. So it is Beauvais, right? We're coming down on that constitutionally,
That's what I
Beauvais.
went for.
All
That's
right.
what I've heard, and
I
I'm
will,
not sure.
I would look forward to speaking that way during his future
Constitutionally.
arraignment as well. Here's the thing, Corey. I mean, I get that the Trump doctrine is break the law and dare the courts to do something about it.
Right,
And this echoes something we saw in the first term. Remember back when the DOJ and DHS were resisting court orders during the Muslim ban.
right.
So, I mean, what does it mean, both symbolically and practically, if an administration just treats federal court orders like spam mail and Congress doesn't mind?
The statute of limitations on most criminal offenses is 5 years. So one possibility is that we'll get prosecutions for this eventually in the next administration. If they don't make the mistake, as Biden did, of thinking, oh, we don't want to seem vengeful. No, the law has to be enforced, or you get the destruction of the law. You get the self-coup that we're seeing. The reality is, that normally it would be Pam Bondi, that would be the Attorney General, who would bring these charges. But that's not likely to happen. In the Nixon case, you had special prosecutors appointed. I don't see that happening here, and they did eventually result in the prosecution of a Nixon Attorney General even during the Nixon period. In fact, that's actually what the case, U.S. versus Nixon, was about, even though it named Richard Nixon to try to make a symbolic point of his
Right.
involvement. So, that's unlikely to happen. So what could happen? There's some possibility, and there are legal maneuvers, as I understand it, where a judge can appoint essentially a special prosecutor himself. Now, that would be highly unusual, but in the case of a contempt of his court to preserve his integrity, his branch, maybe something like that might happen. It would be extraordinary, but it's a small possibility, I would say.
But in the meantime, though, I mean, if a cabinet level official orders a federal agency to violate a court order, there's no recourse for citizens or Congress in real time. They can just do it.
You could have a contempt inquiry. You could have the judge beginning to look at that. But yes, the problem with prosecuting contempt is who's going to do the work. It's normally the Department of Justice. They're going to refuse to do it. So I'm opening this possibility, and it's true in your hypothetical too, that a judge could just, who really was sick of it, say, I'm going to appoint my own lawyer here to look into the court is going to appoint a lawyer to defend these administrative officials if they won't defend themselves, and will potentially hold them in contempt. Yes, that's a possibility. And now you get to go back to our episode with Glenn Kirshner way back. This really is a record of all this. You see how it all connects. There's an additional problem. And I have a YouTube video about this where I went out, where the U.S. Marshals are located in the Thurgood Marshall Courthouse and filmed it in front of them. But I asked the question, who are these U.S. Marshals in the instance in which you do have a finding of contempt by a court? Who carries out the arrest? It's supposed to be the U.S. Marshals. but they don't work for judges. They're part of the executive branch. So if Pam Bondi's arrest is ordered by a judge, it's Pam Bondi's subordinates that have to carry it
Oh,
out. Now you
say it
see the
slower.
complication.
Say it slower. Say it slower. All right. So this administration can now blow past legal limits on war, deportation, and court compliance. I think the smart Democrats are going to be the ones who run about on bringing back a state of checks and balances for 2027. We got to take a break. Let's come back in just a moment because we really didn't get to talk about the major Supreme Court ruling last week. But boy, these judges have wanted to beat up on one particular defenseless, marginalized minority for many years, and they finally got their chance to do it. We'll be right back on The Oath in the Office. Welcome back to The Oath in the Office, starring Professor Corey Brettschneider. I am his evil henchman, John Fugelsang. So, as you guys may remember, I know this was like 19 what the F's ago, the Supreme Court dropped last week one of the most easily predictable 6-3 rulings of the term, a ruling so cruel, so dishonest, and so medically ignorant, it could warm the hearts of anyone who feels they missed out on separate but equal. The six Supremes, you know, Corey, the six, the Federalist Society's Handmaid's Tale cover band, they gave us a brand new gift for Pride Month, upholding the Tennessee law to block gender-affirming care for transgender minors. We're not talking about gender surgery. Okay, they just ruled that states can ban gender-affirming care for trans kids, like puberty blockers or therapy, because apparently they don't have it enough, and the Equal Protection Clause really works better as a decorative throw pillow. Corey, I have this theory about this case. You see how seriously Americans take the words freedom and liberty by how they think transgender folks should be made to live. And you'll learn a lot about how much they oppose big government when they have zero problems with that government coming in between a family and their doctor. So the 6-3 decision said that the law doesn't violate the Equal Protection Clause, and it lowered the level of scrutiny courts should use in other states when evaluating all the many inevitable copycat bans that will now come. So let's begin with the core of it. What is your view of the majority's claim that Tennessee's SB1 does not discriminate based on sex or transgender status, and is that consistent with equal protection jurisprudence?
I think they're dead wrong, and I'll say why. But I first want to just give some voice to what their argument is. And
Please.
it goes back to another, I think, terrible case, which is called Gedelig. And that's a case about discrimination against women. Although what the court said in that case is they weren't discriminating against women, they were discriminating against pregnant people. And that was okay under the Equal Protection Clause. It concerned the denial of benefits of prenatal and other care to pregnant women that was clearly discriminatory towards women, and yet the court wouldn't use its jurisprudence about gender discrimination in that case because they claimed it was about a medical procedure, not about the people who received that procedure. Now you can see how their reasoning works here. It's the same idea. They're saying, look, we're not discriminating against transgender people. And I should say that the court, in an amazing decision called Bostock, a surprising one, did protect under the 1964 Civil Rights Act the rights of transgender people in employment, saying straight up that, you know, this is gender-based discrimination and it's banned here. Now, there are a couple of differences here. One is this isn't the 1964 Civil Rights Act that we're talking about. It's the Equal Protection Clause, and they're saying that's really not about transgender protection. That's one way I read it. And more specifically, the way that they're doing that, without saying that directly, is they're saying that this is about medical procedures and discrimination against people who want to receive certain medical procedures. So in the same way they said, well, we're not discriminating against women, we're discriminating against pregnant people. They're saying we're not discriminating against transgender people, we're discriminating against people who want puberty blockers and other care. Now, what's wrong with that is that it's so intertwined, of course, with discrimination against transgender people. These are medical decisions made by doctors in consultation with people who, you know, sometimes there are questions of life and death or suicide that are at issues here, about fundamental questions of identity. And to distinguish the medical procedure from the identity of being trans, I think is just a huge mistake, and it's disingenuous. The court knows that's not what's going on. So it's a terrible decision. And, you know, it's unfortunate because I certainly opposed Justice Gorsuch, as you might remember, when he was nominated for the Supreme Court in the New York Times and in Time magazine, saying this is going to be a dangerous opponent of gay rights. And
Yeah.
my worry ongoing was connected to that, also an opponent of transgender rights. And as much as he, in the Bostock opinion, which he wrote, surprised me, my worry is, well, he's trying to show he's going to protect gay and transgender people when it comes to this statute, but that he's also simultaneously undermining the Equal Protection Clause. Now, I don't really want to scare people, but I also want to put the stakes on the table. It's the Constitution and a combination of the Equal Protection Clause and the Due Process Clause that ground the right to gay marriage, specifically the fundamental right to marry applied equally under the
Right.
fundamental rights doctrine of the Due Process Clause. So if he's digging in here to transgender rights, what maybe he will undercut in the future if he has the chance, and certainly there are members of this court who do, even more fundamental protections for gay and transgender people.
Absolutely. Well, I mean, Justice John Roberts, human aristocratic sweater vest, he's insisting that SB1, it just removes one diagnosis, gender dysphoria, from treatable conditions. That's all. But this seems like a real workaround to target transgender people and transgender youth without naming them outright, which seems like a dangerous precedent for groups the majority doesn't care for.
And let me just say, the court, when it comes to, and people are going to find this surprising, but when it comes to certain examples of what the court calls animus or intentional discrimination, it's very vigorous in its defense. So in the famous cake case, when the maker of cakes didn't want to provide a cake for a gay wedding,
Right.
they found for that cake maker on grounds that when he applied for an exception to the civil rights law that required him to not discriminate against gay people in the production of and sale of his materials, of his cakes, it turned out that one of the people who did not, in the Civil Rights Commission that was looking at his request, said something about the history of discrimination by Christians against gay people. That was enough for Justice Kennedy and the entire court to say, this is animus. It's intentional bigotry against this cake maker. Now, here you have just evidence after evidence that this isn't just about a procedure. It is discrimination, animus towards transgender people. And yet the
Yeah.
court refuses to say what's obvious to me. And, they had an easy way to say that. They could have said it as simple as day. They could have used the cake case to say, okay, you can't discriminate against Christians and you also can't discriminate against transgender people. But that's obviously not how they see things.
Yeah, well, I mean, it seems like they avoided ruling on whether transgender citizens constitute a suspect or a quasi-suspect class, which would be a key constitutional question. I can see why they would dodge it, but
They dodged it, yeah.
Justice Sotomayor's dissent, to my clueless reading, it argues that the law should be subject to intermediate scrutiny. Can you walk us through what that means, that standard, and why it matters, whether the court applies intermediate scrutiny versus what, rational review?
Yes, and can I just say,
You're like
I'm
my
so
law
thrilled.
school, man. I'm going to be
Look,
able to pass the bar after I host this podcast.
and you save whatever that is, about $180,000, 3 years of law school, 60,000 tuition, plus room and board, of course. So yes, let's save some money. The Equal Protection Clause. But I have to say too, I love this question. I cannot imagine being on MSNBC and they're like, can you walk us through the different levels of scrutiny at the heart of the Equal Protection Clause? And yet, if you really want to get into this case and understand what's going on, and let's not, hide from the fact, which you've said so clearly and brilliantly, this is about legalizing bigotry. So how
Oh,
could
yeah.
they do that? And you've really got to dive deep. So let me give an answer to
And
your question.
in fairness to cable news, I mean, I grew up doing broadcasting. You can't go deep on this. We do a podcast so we can ask the smarter questions,
Yeah.
or in my case, the more stunningly clueless ones. But go ahead, please.
Yeah, we have more time, but this is the kind of media I think that allows you to really learn as opposed to just kind of give a soundbite. So I'm thankful for it. The Equal Protection Clause, the way the court has seen it for a long time, has different levels of scrutiny, as they call it, or in which they balance the way that you think of the rights of an individual as opposed to the government's entitlements to act based on its own powers. Now, let me just break that down in the simplest of terms. The court's doctrine says if there's a distinction based on race, it's going to be really skeptical of that. And you see the reason for it. The Equal Protection Clause is passed in the 1800s after the Civil War in order to, during the Andrew Johnson administration and ratified, in order to protect against discrimination against Black Americans. So race it's especially suspicious of that. And it's going to almost certainly find against the government when it uses a race-based distinction. That's the doctrine. Now,
Yeah.
what Justice Ginsburg did brilliantly is she said in the 1970s, at the same time that the ERA was being considered, and the ERA also would have upped the level of scrutiny
Right.
to the same as race. But what Justice Ginsburg tried to do, and did do successfully through an amazing litigation strategy, was say, well, there's an analogy between discriminating against people based on race and discriminating based on sex and gender, because they're all arbitrary distinctions. And so if you're doing that kind of discrimination, we should up the level of scrutiny, be suspicious of laws. So she created, essentially, through litigation, a second category called intermediate scrutiny. She didn't win what she wanted, which was the highest level of protection, strict scrutiny, but she made it so that courts have to be very suspicious of any distinction based on gender. Now, the obvious thing, and this is what the dissent is saying here, is to say transgender discrimination is gender discrimination. And so under these rulings of the 1970s, we should up the level of suspicion, or the level of scrutiny is another way to put it, to put pressure on those laws and likely to fine for the defendants. And if they would have done that, the government can't just say, here are our reasons we're worried about, and give some frivolous reason. The reason has to be a really important one. This is the doctrine, the language of the court. For the goal here has to be really important, and the way that we're pursuing our goal has to be minimally invasive when it comes to people's entitlements to do things
Right.
like choose their own care. Now, they didn't do that. And why didn't they do it? Vibes is the answer that Leah Littman gave us in her discussion
Yes.
with us. The
That's a
dissent
polite
is so
answer.
right. It's obviously gender-based discrimination. It obviously should have resulted in a higher level of scrutiny. Intermediate scrutiny sounds right to me. And yet the court ignored its duty, as it has been doing in so many cases. And instead of acting on law, I'll quote Leah Littman, go back and listen to that episode, the court was acting on vibes.
Absolutely, but let me build on that by saying, yeah, the only two issues I can think of where our conservative friends don't mind the government getting in between a citizen and their doctor are women's reproductive freedoms and gender affirming care for transgender children and their families. So this is very much a case to me about medical autonomy. Can you speak to how the court's ruling potentially narrows any zone of protected healthcare decisions, and what that might mean for other groups, including adults who might be medically unpopular with future courts?
Well, it opens a litigation strategy for bigots who can now say, oh, we're not discriminating against transgender people. If they're smart and they understand the law, they'll know not to say their bigotry out loud. And that might protect them as they claim to simply be discriminating against certain kind of medical treatments rather than against people. And that's an unfortunate reality. And, when we start to think about rebuilding our democratic constitution, which is in shambles, this is another issue, like the war powers,
Yeah.
like the due process rights of non-citizens that we have to start to rebuild. And so, maybe we haven't done enough hope in this instance, but these dissents should give us hope. And the fact that we are talking about a dissent, and that we talked in depth about the idea of Justice Ginsburg, intermediate scrutiny, the fact that that could be used in these transgender cases. There have been a lot of moments in which in recent history in which it's worked. Think of gay marriage, worked through the courts. Think of the Bostock decision guaranteeing, and which still exists, the rights of transgender people in matters of employment, using not the Constitution, but the 1964 Civil Rights Act. That's where the hope comes from. You see that it's not just that all is lost, that there's an
Yeah.
ongoing battle between an authoritarian idea of the Constitution that the court is using again and again, and a democratic one. And so I'm hopeful that these dissents can inspire us. Remember, Plessy versus Ferguson, majority of the court, but it had a dissent from Justice Harlan,
You're
talking
right.
about the fact that, the Constitution protected against segregation because it was subordination. And eventually that became the law. So that's the kind of battle that we're engaged in here too.
So, I mean, to me, it's like they're saying we're not banning gender affirming care. We're just making it illegal to affirm gender. It's like saying we didn't ban food. We just banned eating for hungry people. And we should point out that this could kill kids. Trans
Yes.
kids in states like Tennessee and Florida and Texas are going to be completely cut off from care now. And the American Academy of Pediatrics acknowledges the medical necessity of this kind of care for improving the physical and mental health of transgender citizens, but these hacks in robes know more about medical care than pediatric endocrinologists or families who love these kids. And to me, it reminds me of Dobbs. 3 years ago, they said,
Mm.
we're not banning abortion, we're just letting states ban abortion. And they've seemingly copied and pasted that pass the buck logic onto trans kids. So you can't get an abortion, you can't get gender affirming care, you can't teach black history, you can't protest what ICE is doing, you can't have due process. But hey, your corporation's allowed to ban Juneteenth as a company holiday. I guess that's where we're at right now. But what echoes do you hear, Professor, between this case and past constitutional moments like the court's response to desegregation or the initial LGBTQ rights of the early 2000s?
I mean, and to really pull back, certainly I agree with what you said about the echoes of Dobbs, that in the same way that Dobbs really got rid of a civil liberty, which really entitled a woman and her doctor to make decisions together based on medical necessity and based on choice, that's gone. And they've done that again here, and especially when it comes to kids. And again, a lot of the origin story of how these medical interventions got started were to stop suicide of children. And so, it's horrific that the court is allowing these kind of interventions. But if you pull back even more, the pattern is disturbing, but it's a long-standing one. And I've often talked about the two constitutions. We have one that is deeply authoritarian, that aggrandizes presidential power, and I'll try to pull the entire episode together. Those who stress the president's war power as a kind of autocratic thing based in the commander-in-chief, despite the fact that it's Congress that has the power to declare war, emphasize that authoritarian constitution. Those who stress there are no due process rights of people, even as they're being sent to countries like Sudan where they're going to be tortured, are stressing the authoritarian constitution. And yet again, here, the people who would usurp the private, personal relationship to preserve life between a doctor and patients, what are they doing? They're intervening in a theocratic spirit, I think, and we'll talk more about that,
Yeah,
with an authoritarian idea of the Constitution.
that's one of my favorite subjects. So, I mean, Corey, we had a long one today, and this with no guest. We covered a lot of ground, and I thank you for it. After all this, I have to conclude in my favorite way by asking you, in light of all this Michigas, Professor, what is giving you hope?
Well, this is a tough week. And when you have all these different cases coming down and war, it's a frightening moment. And so, one thing I've really not wanted to do is to try to skirt over and definitely not have a podcast where we say it's not a big deal. We're leaning in heavily this week to what the dangers are. But I always am in each of these cases given hope by how bad things were. So I mentioned Plessy versus Ferguson, and that wasn't the half of it. There also was Woodrow Wilson, who in The Presidents and the
Yeah,
People,
you're
five
right.
leaders who threatened democracy and the citizens who fought to defend it, who I lean into that case and show how he went so far beyond what Plessy said, really embracing the idea of white nationalism. And if you think that Trump on Twitter or Truth Social is inventing new media, he was using the new media of film to spread his
That's
lies and
right.
his glorification of the Ku Klux Klan by celebrating the new medium of film and Birth of a Nation. So how bleak did things look at that time that even William Monroe Trotter, who tried to stick up for the Equal Protection Clause, the same clause that we're talking about today, passed in the 19th century after the Civil War, to revive it, confronting Wilson in the White House, leaking the transcript so that we could see it. Things look so bleak to him, and I've mentioned this before, that he commits suicide. And yet, we prevail. We prevail in
Yeah.
Brown versus Board of Education with the 1964 Civil Rights Act, that same law that allows for that victory in the Bostock case. So as bad as things look, it has been worse, and we have
That's right.
prevailed. And when I talk about reviving the democratic constitution, I think we will do that in the future.
I agree with you. This Supreme Court once upheld Japanese internment. They upheld bans on interracial marriage. They upheld segregation. And history doesn't forget these rulings. It condemns them. And
Mm.
history will condemn this one too. I mean, future generations of young Americans won't be as frightened of trans people as our 2025 adults are. Look at all the young people who don't understand 20th century homophobia. So I think you're right, Professor.
Mm.
This ruling will age about as well as Donald Trump's wedding vows. And these justices just carved their names on the wrong side of history yet again. Corey, it's always an honor for me to do this with you. I learned so much. What is the best way for our listeners to follow you, Professor, and keep up with all your brilliance the other 6 days of the week?
I'm on Blue Sky. Join me there as Democracy Prof. Check out our YouTube channel if you want to see a video version of the show and clips. That's at The Oath in the Office on YouTube, and on Twitter at Brettschneider C. And what a pleasure, John. I just have to send my praise back. The
Stop
ability
it.
to talk about this and to be entertained in the midst of all this destruction, you're giving me
Wow.
and all the listeners a real gift.
That's a bit that's a bit extreme entertaining, but I'll take your mercy compliment. And I want to thank everyone for listening. Thank you to Wendy and everyone for putting the podcast together. You can hear me every night on SiriusXM Progress or every morning on the John Fugelsang podcast, which is highlights from last night's show. My book is called Separation of Church and Hate: A Sane Person's Guide to Taking Back the Bible from Fundamentalist, Fascist, and Flock Fleecing Frauds. That's releasing this August, and I'll be promoting it obnoxiously and relentlessly. Corey, thank you so much. This was such a pleasure. We'll see you all next week on Oath in the Office.